Okay, we're all, as we're quorate, everyone here, not waiting for anyone else on either side. Well, welcome back, Mr. Kaczmarek. Welcome to the witness seat. You've been in the room up until now, so you know who we all are. I'm not going to do any more introductions. You've got a witness declaration in front of you. I'd be grateful if you could read that into the record, please.
Certainly, and I did notice this is the fact witness declaration. I'll read the expert one. I know that one, if you'd like me to. Right. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. Say with Candace.
Thank you, Mr. President. Mr. Kaczmarek, we have passed around a binder which is in front of you, and we've given it to the tribunal and translators and opposing counsel and the transcribers. Could you please look behind tabs 2 and 3? Do you recognize those documents?
Yes, they are my first two expert reports.
Do they accurately reflect your professional opinion?
Yes, they do.
I understand you have a presentation that you would like to give.
I do.
Please proceed.
Thank you. So I'm going to divide my presentation up into 4 sections. First, we'll talk about the real estate market, the relevance of purchase prices and dates in this case, flaws I've identified in FTIs, appraisals, and then severance damages. So turning to the first slide in section 1, slide 4. Basically, as you have seen, I believe there's a correlation between the real estate markets in the U.S. and in Costa Rica. It's agreed between the experts that Costa Rica and Costa in particular is influenced by North American buyers. North American buyers are the same buyers of properties in Texas or California or Florida. The Gold Coast in Costa Rica is just like another state. So, and I'll show you a little bit more about the correlation as we go through. This was a market from 2003 till about 2006, really, that experienced bubble prices. It was, if you will, there was a mania about prices in the area. And you can see that from the quotes here. I won't read them all to you. There's many more I've put in my reports. But I think if you look at those publications and listen to and read what the realtors were saying, this was a very hot market for several years. And then it crashed. Crashed harder than the U.S. market did because I think the bubble prices were even higher. And what you can see, and I'll just read you the first quote at the top here of page 6. Prices for vacation homes and condominiums in the Central American country, that is Costa Rica, have dropped by as much as 40% from their peak a few years ago, and sales have slumped 30% over the past 6 months, they say. That's a publication from August 2008. So when they say a few years ago, they're talking about a peak clearly before 2008, talking about a peak really in 2006. And if you look at the Case-Shiller Index, an index of real estate in the United States, it goes up pretty sharply. It peaks in 2006 and then falls. So clearly a correlation with the Gold Coast property market. Not a one-to-one correlation probably. It could still be a correlation if for every dollar the Case-Shiller Index goes up, $3 properties go up in the Gold Coast. That's still a correlation. I would add too that that was not in dispute in the Glaube case. In fact, they valued their property in mid-2006 precisely because it was the peak. So that had been agreed before. And this is what Mr. Hedden's index looks like. You can see no correction at all in '07 and '08. He has it going up and then flatlining. And you can see I've put another quote here from the same, I think it's the same publication, talking about how sellers were cutting their prices by 20 to 40% compared with 3 years ago, again indicating the market had peaked prior to the selected valuation date of claimants. So in that sense, as I've said in my reports, Mr. Hedden's valuations are all overstated because I think he has misanalyzed the market. So purchase prices and dates. I may spend a little time on this slide because I do think it's very important. I've said in as many ways as I can think of saying, and I'm going to say them in my presentation, of why I think the claimant's claim for damages that they've put forward is improper. And the way I've put it here is simply that claimants cannot or should not be able to benefit from, one, the existence of the park or the controversy by getting a lower price for the property, and then in this arbitration assume away that the park exists or the controversy exists and get a higher value in its claim. And I've put here a quote from Rosinvestco versus Russia. This was a case of about a shareholder who had invested in some UCO shares, and I think it's worth reading. It says, the LACG report assumes that the taxes were imposed on UCOs, enforcement actions announced and expected by the markets, and claimants bought shares in UCOs at a price in which the market had taken these events into account or had overestimated the impact of these events on the price, meaning the price was really depressed. The LACG report also then assumes that following claimants' purchase of the shares, the taxes, enforcement measures, and auctions would not have taken place. This approach is divorced from reality. And I think you have the very same situation here in this case. The risks existed on the date when claimants purchased. As we've said, they knew or should have known about these risks. And then they're doing a valuation assuming those risks don't exist. I think there was a discussion about sometimes there's differences of when you would take risks like this of expropriation or such into account. In the Unglaube case, for example, the Unglaubes had purchased their properties in the 1980s, before the 91 decree. And so there, because they could have no idea, of course, about a park law coming into being, they didn't get the properties cheaply, because of the existence of the park. And so in that case, there was no argument by myself or the respondent that Mrs. Unglaube's, the value of her property needs to take into account the park. We fully agreed it shouldn't because she purchased before knowledge of the park existed. This case is very different. This case, the claimants definitely knew the park was there, that they could be expropriated, and I think those risks need to be taken into account in the valuation process. So we've said because of that, the purchase prices are relevant. And of course, you'll see there's many inconsistencies, unfortunately, in the purchase prices and purchase dates. And in fact, we continue to, even in the last few days, I heard about new purchase prices I had not known about before. And of course, we wanted to see the sales and purchase agreements, but they were not submitted by claimants to review because I think the terms of those agreements would be quite helpful. Turning to slide 12, what I thought would be helpful is if I walk through a timeline and the purchases together, because I think that'll help you see some interesting aspects of the data. And I don't submit that I'm going to hit every relevant event on the timeline in my discussion. But obviously, starting out and in the shaded areas, these are sort of the events. You know about the decree and the law. And then as you'll have seen in my report, we talk about Mrs. Unglaube's Phase 2 property being declared in the public interest in July 2003. That was then published in November 2003. And so then you see in August purchases by Mr. Spence in the Ventanus area, and then Mr. And Mrs. Kofer. Now, you'll see I have some data points, the lot, the size, the price, the per square meter price, and then the value ascribed by FTI. The purchase price for Mr. and Mrs. Kofer is very low. That's because we took the price from the certificate at the registry in Costa Rica, which said 500,000 colones. Same thing for Mr. Berkowitz's purchases. In fact, in the first FTI report, they said that he purchased every lot, the 8 B lots, for $500,000 each. We said that doesn't seem to be right. There's a mistake, we think. And Mr. Hedden said, yes, you're right. It actually is 500,000 colones, which is why I've prepared it, assuming 500,000 colones. But now I've heard Mr. Berkowitz say, no, I got all the B lots, not just 1 through 8, but 24 for 1.5 million. I still haven't seen any evidence of that, any documentary evidence, but it indicates it's a very low price, higher than what I've represented here, but still clearly a low price. And as I think he indicated in his testimony, he knew there was a risk of expropriation. And then you see at the bottom, September 2003, Mr. Spence purchases 2 V lots for about $250 a square meter. And just put those numbers in your head, the 250, because I want to come back to that. You then have, in February 2004, the Attorney General opinion. Now the C-word issue is being dealt with, that the park really does run inland, and you see more purchases by the claimants. And the first one, Mr. Gramillion from Mr. Berkowitz of B7, we're told it's at $425,000. It's 5 months later after Mr. Berkowitz had purchased all of the B lots. So in 5 months, he flips 3 of the lots along the beach and gets back about, I think it's 83% of his purchase price for the whole B lots. We look at that purchase, we say it looks like Mr. Gramillion probably did not know those properties, his property he bought was in the park, because you can't really explain whatever value of 1.5 you want to ascribe to the beachfront lots that Mr. Berkowitz purchased. This would be an incredible jump in value. So it looks like to me he was unaware of the park. And then you see a few other purchases continuing throughout 2005. You see C71 for $230,000 in February 2005. Put that number in your head. I'll come back to it as well. And then a series of additional events take place. The B lots are declared in the public interest. The Supreme Court issues an initial decision about the park extending inland. The Attorney General issues its opinion again, and Spence Co. says it knows about the Attorney General's opinion. And we have more purchases. We have Mr. and Mrs. Kofer and Holston purchased 2 V lots. And what you can see, I remember I said I'm going to come back to that average per square meter. These are roughly, again, around 250. One's a little closer to 300, but the other one's lower than the others. So this indicates that from 2003 to 2006, the V lots aren't going up in value. That makes sense. The V lots are subject to being expropriated and being part of the park. There would be no reason for it to increase in value if that risk is still attached to it. Okay? And then you have a sale of V61 by Spence Co., which we say had the boomerang clause, meaning they could basically get a refund or put the property back in case they couldn't go through with it. So here, Spence Co. clearly knows other people in the market are aware park exists. And then you have Spence Co. purchasing the SPG lots in late 2006, and then the V59 lot. And then finally, you see in October 2007, the C71 lot goes on the market from Spence Co. at the same price they say they purchased it at several years ago, $230. So again, it's an indication that properties in the park are not increasing because they're subject to these risks. So FTI has said in its second report, the purchase prices and purchase dates are completely irrelevant. I couldn't disagree with that opinion more. Obviously, these are the exact lots to be valued, and knowing when and at what price they were purchased is important. If I understood Mr. Hedden's testimony, what he said was you could use a purchase price and index it, but not in this case because the properties were purchased below market value. And I think we need to tweak that just a bit, because it's not that they were purchased below market value. There is a market value for a price or for a lot that has a risk of being in a park and expropriated, but it not being fully clear yet. So I would say the purchase prices could be indicative of market value with those risks attendant to it. What he says is market value is none of those risks exist. So I'm just saying the market value is lower because it has those risks attached to it. And you know, I think you've heard from the witnesses, you've read the testimony. Yeah, I won't read all these quotes, but these quotes all indicate claimants were aware that there was a park. In fact, as Mr. Reddy has stated, he assumed that there was no way Costa Rica was going to go through with this, that they would never expropriate. So effectively making investments on a bet that they wouldn't follow through and establish the park. In that sense, as we said in our reports, it's as if they're claiming damages because Costa Rica didn't repeal the park instead of actually enforcing the park, because that's what he was hoping for. And then quickly on slide 17, you see, and as I just went through in the timeline, definitely Spence Co. is making investments in properties well after it was abundantly clear to anyone that the properties were in the park. So slide 18 is a diagram. It was in my second report. Again, it's just to explain the concept here that claimants are purchasing and getting the benefit through a low purchase price of the risks that their properties are in the park. And now they're claiming in this arbitration that they are entitled to the value of their properties as if the park never existed and there was never any risk of expropriation. And I just think that's wrong. I've said that's like a form of double counting. It's a form of double recovery, double compensation, or just illogical, divorce from reality, as the Rosinvestco Tribunal said, and shouldn't be a proper form of compensation in this case. What we have said is the purchase prices are, to some extent, the right way to go. They would reflect fair market value unless, for example, like Mr. Germillion, he purchased his at a very high price above what Mr. Berkowitz paid for that lot, B7. We would say we would probably need to adjust that price down because it seems like he was uninformed about the park, and fair market value is an informed party. Okay, and so that's why we've always said in our reports the most they should recover is their purchase price, and we would want to reduce the purchase price for anybody who made an uninformed investment decision. And to do that, we needed the sale and purchase contracts to see the terms and to understand the deal. And Mr. Hedden could have requested those from claimants. They clearly Mr. Reddy, if I recall, consulted with those agreements to change some of his testimony, his witness statement. So they could have been provided, and I think would have been very helpful. So we have done an alternative calculation for you. It is here on this table, and I believe the total is 4.5 million. But again, I think that needs to be reduced, and the quality of the evidence before you is not very good. The purchase prices continually change. They have changed throughout this proceeding without hard documentary evidence, and have changed during the course of this week. So that's unfortunately where the evidence stands for you. And I would just also note, to end this section, the claimants effectively are seeking nearly 8 times the supposed amount they invested, which is obviously a significant profit. So flaws in the appraisals. Mr. Hedden he actually went through this exact table in his presentation, SPG 1. And what I wanted to just point out was, rather than using the purchase price of SPG 1, he used different properties at different dates, including going back as far as 2003, coming up with various and disparate sales prices per square meter, and then made market adjustments to that. Slide 22, this is the same SPG. He then made, besides the market adjustments, physical characteristic adjustments, which I just saw this morning, data that wasn't shown in this table before to indicate how those were made, and then came up with adjusted sales price. Turning to the next slide, 23. This is V31, this is not SPG1, just to alert you to that. Because what I wanted to show here was, in the red box, you see he's saying, well, I've got 3 comparable properties to V31. It could be either $623 a square meter or as much as $1,053 a square meter. There's quite a spread of prices for comparable lots. I'd usually would want to see very narrow dispersions, not very wide dispersions. Narrow dispersions add confidence. Wide dispersions add doubt. And then he came up with an average. And again, for the first time this morning, he revealed how he had placed weights on particular properties. That was not evident at all in his reports. So I think because he's relying so much on other properties rather than the properties at issue in this case, and getting such wide spreads, that not a lot of confidence can be had in the valuation approach. So slide 24. Here was a graph from my first report. And what it shows is we did an analysis and we said, let's look at the purchase price that they've told us is the purchase price. And that's the blue bars. And we just normalized everything to be equal to 1. And then we said, let's apply Mr. Hedden's index that you've seen of market increases in prices to the purchase price. And that's the red bar. And then let's look at his actual valuations of the properties. And that's the green bar. And what you can see is, except with Mr. Kofer's properties, Mr. Hedden is valuing the properties significantly greater than his own market index, which would not seem to be rational. And he says in his second report, well, it's because these things might be below market value. And again, I would say it's not that they're below market value. They're at a market value reflecting the risks attendant to these lots. And so we did this analysis, And this analysis is basically doing the reverse, taking his valuation back at the market index and then comparing it to the purchase price. And you see in almost every instance, the blue bar, the purchase price, is less than the red bar. But there's some anomalous stuff in the data too, I think, reflecting the lack of confidence in the reported purchase prices. So turning to now some other flaws in his valuations. So that's really, I think, in the way he's gone about it, he's ended up with values that are much greater than I think would suggest from a strictly indexation approach. Not to mention that his market assessment I thought was wrong, but there's other characteristics I think he's applying in his valuations which also inflate them. And this is the alleged views of the beach and the ocean. And that's exactly sort of the crux of why the park was created in the first place, was to not disturb the nesting grounds of the turtles. That is not only noise, but most in particular, lighting. So Mr. Hedden tells you people were going to build very tall houses with lovely views over the top of the vegetation there. And that was not going to be allowed. That would just defeat the whole purpose of trying to protect the turtles, because then there are lights in the windows on second floors and the turtles see the lights and are distracted from actually coming to the beach and nesting. So I just think he's valuing it under that characteristic when that characteristic wouldn't have been allowed. It wasn't even allowed back as early as 1992. The Unglaubes basically, as I said, bought their property in the 80s. The park law came out, and very quickly after the park law came out, they offered to donate 50 meters of the 75-meter strip in the Phase 1 development, and signed an agreement with the government about doing that, specifically to increase the setback and get the houses away from the beach, and so the lighting would not affect the turtles. So if you walk along that part of the beach, maybe someday, I have, there's no wonderful, great views. There's a lot of vegetation between the houses and the beach. So these views just don't exist. This is a view. I've been there. I've been to the area 3 times, twice in 2010 and then again in 2014. So I've been there in the dry and the rainy season. This is the rainy or non-dry season. You can see there's a pretty tall set of vegetation between the beach and where the properties would have been built. Importantly, there's quite a bit of the 50-meter inalienable zone, the public zone. A lot of that, most of it, is in this vegetation. It hasn't been evident to you, but high tide comes up nearly to the vegetation. So mean high tide's a little lower than that, closer to the ocean. So a lot of this 50-meter inalienable zone contains this vegetation. I'm on slide 28 now. This is within the vegetation, looking out, and you can see it's a pretty thick canopy. On the right, it looks like there's an opening. That is an opening. That is an access point to get through the vegetation to the beach that has been established. Always done, for example, in an S shape, so that if you're on the beach, and even though there's an opening, it looks like there's vegetation right behind the opening. So maintaining a curtain, if you will. This is another view, and that marker is the 50-meter marker. So you can see there's quite a bit of vegetation between that and the beach. And this is Mr. Hedden's photo in the dry season. You can still see there's bunch of foliage, even though it's dry. And so the views are still quite obstructed, and don't offer, I would say, the lovely beach and ocean views. And then there's a number of other issues, of course, in valuing these properties. We've talked about them, the density restrictions, height restrictions, as I just went over. Those are problems. And I think maybe most importantly, you asked a question earlier about, well, what if we had a different valuation date? I had done that analysis originally in the Unglabe case, assessment of the market. The market has been awful since the peak.
I'm sorry, I object to this. The witness is going well beyond the scope of his report. He's given now on a number of occasions evidence about what happened in the UNGLUB proceedings. None of his expert reports from that proceeding have been produced, nor has any of the documentation or evidence, and I don't think it's appropriate for the witness. I've given him a lot of latitude in already, and I object.
I think it's fair enough. I mean, the UNGLUB report is in the record. There's a lot of material that's there, but I think it's fair that you keep your presentation now to your report. No, not the expert report. I meant the award.
Correct, the award. And a lot of this, of course, I'm saying is in the award about the 92 agreement and all that. But
I think the objection, though, is well made in the sense that the intention of this presentation is to enable you to present your report to us rather than to go beyond it.
Certainly. In that respect, I then will just refer, I did talk about the market, the current market, in my report in this case, extending what I had done before. And what I had written to you and said was, we went through the properties and looked throughout the region again. Nothing has happened in this area, absolutely nothing. No development. In fact, all we saw were more lots on the market and lots on the market at a significant discount. The Unglaubes I referred to, they had lowered their prices, I think, 60% from what their previous asking point was. Still no buyers. So what happened was an incredible bubble of prices, and as I said, of a lot of buyers who never intended to really develop. They were caught up in the ever-increasing price escalation in the mid-2000s and got left holding a property that they paid a lot for that they cannot sell but for a loss today. And so this is really, that mania has really had a bad impact on development in the area. Last topic, severance damages. It's been talked a lot about already, so I can minimize my comments. It is correct that Mr. Hedden has valued in the but-for scenario the whole of like the SPG lots using beachfront properties. And then in the actual scenario, or after taking, everything's valued using interior lots. He did say today, in all fairness, that he made a large adjustment to the beachfront lots. This is, again, something that was not in his report or his tables. It was new to us, new information, not explained. But I still think the approach does not make sense to me, just logically. You've seen these two diagrams. They're the diagrams that we put in our second report. And the simple explanation I think we're giving is the lots, particularly those that now border the park, are frankly improved because they're the closest ones both to the park and the beach. And so just the whole concept, I think, Mr. Hedden's applied to severance damages in this case is flipped on its head. So I would think the green at the bottom, the green lots, the ones now closest to the beach and bordering the park, would be more valuable than they were before. And I don't really think the other ones would change in value much, because they're still same distance from the beach as it was before. And if you look at Mr. Hedden's development model for SPG, which is sort of his DCF model, he actually recognizes, of course, those lots beyond the ones that would border the 50-meter zone have a much different value. The interior lots in his development model, I think he has an assumption of selling them at $420,000 a square meter, or not a square meter total for the lot, whereas the alleged beachfront lots would go for $1.2 million. So significant difference in value that I think actually is a contradiction between what he's now saying regarding severance damages. So slide 35, final slide. This is the severance damages calculation by lot, and as we've indicated, it totals more than $13 million, or more than a third of the total amount claimed in this case. And that's the end of my presentation.
Sorry.
Go on.
I have no further questions.
Ms. Cohen. And I'm happy to say that these bundles have already been provided to the interpreter.
I assume by this point, Mr. Kaczmarek, that you're already aware that my name is Tracy Cohen and I'm counsel for the claimants, and we'll be asking you some questions about your 2 expert reports that have been filed in this proceeding. You understand that?
Yes.
Mr. Kaczmarek, you're not a licensed or certified appraiser, is that right?
No, I hold the designation of Chartered Financial Analyst.
And you don't hold any designation as an appraiser, is that right?
That is an appraisal credential, absolutely.
You're not a licensed or certified appraiser.
No, I don't have a designation other than Chartered Financial Analyst.
And you're not a lawyer?
Of course not.
You don't have any, you're not a member of any appraisal institute, correct?
Again, I would regard the CFA Institute and its satellite organizations as appraisal institutes. Absolutely, so I am a member.
You're not a member of any specific appraisal institute?
If by specific you mean for a particular industry, like real estate or mining or oil and gas, no.
And you don't describe yourself as a real estate appraisal expert in particular, is that correct?
That's correct. My background covers all asset classes, as I've explained, so I don't characterize myself as a specialty in any one particular area.
You did not apply the uniform standards of professional appraisal practice in the preparation of your report, is that correct?
No, it's not those principles aren't necessarily applicable to me. What I did in this case was provide a damages analysis. That's first and foremost what we're here to do, and provided evidence of values that could help the tribunal resolve this case in a fair way.
Mr. Kaczmarek, I'd appreciate it if you just answer my questions. I asked you whether you applied the uniform standards of professional appraisal practice, and I take it that the answer to my question was no, you did not. Is that right?
Correct.
And you didn't apply the requirements of the Code of Professional Ethics of Appraisal Institute in the preparation of your report or the carrying out of your engagement in this proceeding. Is that correct?
I don't know what those ethical requirements are. I didn't apply those. There are significant ethical requirements for the CFA.
And in fairness to you, you haven't done an appraisal of any of the subject lots in this proceeding. Is that right?
I have done an evaluation of the market and of the properties in this case. And based upon my evaluation, I have come up with what I think is the appropriate way to compensate claimants should the tribunal get there.
Again, Mr. Kaczmarek, I'd ask that you listen to my question and answer the question that I've asked. You did not perform an appraisal with respect to the subject lots in this proceeding, did you?
I disagree with that. I did do an appraisal. I did assess prices in the market, specifically claimants' purchase prices. My view is, as I just went through, those prices wouldn't have increased. And so those are the relevant prices to be dealt with by the tribunal in this case. So that technically is an appraisal as of May 2008.
Were you instructed to do an appraisal opinion?
No, I was instructed to assume that the claimant's properties have been expropriated and to determine the appropriate amount of compensation in this case.
Were you instructed as to what date to assume the claimant's properties had been expropriated?
No, I wasn't instructed on that. Obviously, Mr. Hedden had already indicated a date the claimant wished to be compensated. I was using the same date.
You haven't performed, the reports that you have performed, that you have provided are in part responses or comments on the reports that have been tendered by Mr. Hedden, is that correct?
Correct.
And in responding to those two reports provided by Mr. Hedden, you haven't followed the same uniform standards of professional appraisal practice in providing a critique report, is that right?
I don't know what those practices are. It's possible my approach could be congruent with those principles, but I didn't have them in mind when I conducted my analysis, no.
If I could ask you to look at your first report, which I believe you have in front of you in the binder that was handed up by my colleagues. And I'd like you to look at your first report. And sorry, just before I take you to that, you made a number of remarks about the on-glub proceedings in your presentation this afternoon. You recall that?
Yes.
You understand that the on-glub proceedings were not public proceedings?
I know the award is public, but no, it wasn't like this particular proceeding. Correct.
You understand that the only thing that has been made public with respect to those proceedings is the award?
Yes.
And did you give consideration to that before giving your comments this afternoon in this proceeding?
Absolutely.
And if I could ask you to look at page 4 of your report.
First report?
Yes. You indicate in page 2 of your report. Paragraph 4. You
Yes,
say
I'm
in
there.
paragraph 4 that you led a team of professionals at Navigant in preparing the report. Can you tell me how many individuals from Navigant have worked on this report?
Besides myself, probably 3 others.
And they're not named in this report, is that correct?
That's correct.
And if I could ask you, who took the photographs that are provided with your report?
I took some of the photographs, and my colleague Andrew Preston, who's in the room, also took photographs.
Do you recall specifically which photographs you took?
No, I don't.
Thank you. And can you tell me, with respect to, sorry, before I get to that, you've been retained by Sidley Austin in a number of other arbitration cases to provide an expert opinion, is that correct?
Yes, that's correct.
And you set out the documents that you've relied upon in the preparation of your report in appendix number 2, is that correct?
Correct.
And if I could ask you to just look at paragraph number 7 of your report that you have in front of me. You say here that you don't speak Spanish, is that correct?
That is correct.
And a number of the documents that are referred to in Appendix 2 are in Spanish. You understand that?
Yes, I do.
And they've not been translated into English, is that right?
I believe that's the case, yes.
And just coming back to Appendix 2, if you could just turn to the back of your report to Appendix 2. Which starts just after what is page 25 of Appendix 1. This lists the entirety of the documents that you relied upon in the course of preparation of your initial report. Is that correct?
Yes, I believe that's correct.
And just if I could ask you to confirm while we're on this point, if you could turn to your second report. Appendix 1 to your second report, just after page 53. This lists the entirety of the documents that you relied upon in the course of preparation of your second report. Is that correct?
Correct.
There weren't any documents that you relied upon for the preparation of your report that have not been listed here. Is that correct?
I believe that's correct, to the extent, of course, that I may have referred to something already submitted by claimants or respondents referring to the laws or decrees. I may not have referenced that here. I think this was an attempt to put in additional evidence which supported our opinions.
If I could ask you to look at the document, the binder in front of you, the blue binder. And if I could ask you to look at tab 9. This is one of the documents that you've referenced in your report. Is that correct?
Yes, probably for the definition of fair market value, I presume.
And that was what I was going to get to, but just if I could ask you to confirm that this is the only extract from the American Society of Appraisers standards that you have referred to or relied upon in the course of preparation of your report. Is that correct?
Correct.
And you already answered what was going to be my question, and that is, I assume that the only purpose for which you referred to it was the definition of fair market value.
Yes, that's the source I use in all of my expert reports, to refer to the definition of fair market value.
And if I could ask you, while we're still in this binder, to turn to tab 12. This is another document that you relied upon in the course of preparation of your second report. Is that correct?
I believe that's correct, yes.
And you did not refer to this in the course of preparation of your initial report. Is that right?
I think that's correct, yes.
And I note that this is the proposed new international valuation standards that was published in June 2010. You see that on page 1?
Yes, I think there's been an update to this. I think there's there may be a 2013 or 14 that came out, but
This is indicated as being a draft, is that right?
Right, exactly, proposed exposure draft.
And do you know, sorry, just before I ask you the next question, I assume again that the purpose for which you relied upon this is limited to the pages that you've included in your document production, is that correct?
Correct.
And so you haven't relied on the international valuation standards beyond what you've included in this tab, is that right? For the purposes of preparation of your report.
In terms of footnoting a statement, no. Of course, I'm familiar with the IVS, and it's always, of course, in the back of my mind in doing my analyses, but I don't think I specifically referenced anything else within this document.
And do you know, with respect to the definition of market value, which is what I assume you relied upon this extract for, do you know whether there were any changes to this definition in the context of what you believe was the 2013 version of the International Valuation Standards?
I don't recall, but sitting here today, I don't think there was any change.
If I could ask you to turn back to your initial report. Page 4 of your report. And looking under the heading Executive Summary to start with, you see where I'm at?
Yes.
And in particular, I'm commenting upon paragraphs 10 and 11. With respect to those two paragraphs, you make a number of statements concerning the factual matters that are an issue in this proceeding. You see that?
Yes.
And were you provided, was this executive summary something that was provided to you by counsel for the respondent?
Absolutely not, no.
Was this an executive summary that you wrote having regard to the witness statements and the memorials that have been filed in this proceeding?
Yes.
You understand that in your role as an expert in this proceeding, your role is not to be a finder of fact. You understand that?
I'm not supposed to decide facts, but certainly facts are important for conducting an analysis.
And how did you decide which facts to choose to include as the basis for your assumptions of your report? Was that something you decided on your own, or was that something that you were instructed by counsel?
I decided pretty much what I thought was relevant. Counsel didn't really tell me what was relevant, because as a quantum expert trying to figure out a damage analysis or evaluation, I don't know if counsel really knows exactly what would be relevant for a damages expert or evaluation expert.
And in preparing this executive summary, if any of the facts as you've set them out here are found not to be accurate, is it possible that that would change the opinions that you've expressed in your report?
Yes, such as if purchase prices aren't correct, that could change my opinion, absolutely.
And what about if the factual issues with respect to knowledge of the claimants are found to be different than how you've set them out in your report? Would that potentially affect your opinions?
No, it would not.
It wouldn't.
It would not, because as we've said, there's enough information and evidence that claimants knew or should have known. As I indicated, there's definitely some evidence, Mr. Vermillion, that he may have not known. But as I've said, he should have known, and the compensation analysis ought to take into account a valuation of his property, assuming the risks that it was in the park and could be expropriated.
Well, with respect, Mr. Kaczmarek, you understand that it's the purview of the tribunal to decide whether or not the claimants knew or ought to have known whether their properties were within the boundaries of the proposed park.
Of course, they're free to agree with my opinions or disagree with my opinions.
And if the tribunal were to find that the claimants did not know or ought not to have known that the lots that they purchased at the time they purchased them were within the boundaries of a proposed park, is it possible that that would affect the opinions that you've given in your reports?
Yes, I would agree with that. As I indicated in the UNCT case, it was impossible for them to know a park was coming. If you were to put claimants in the same shoes as them, not being able to at all predict a park, their properties would be in a park, and expropriated, then it would change my analysis, yes.
And in preparing your summary of the facts and the law, were you told to assume that the 75-meter inland strip from the 50-meter inalienable zone was always, since 1991, within the proposed boundaries of a park?
I was told that the initial Decree 91 established the park and that the coordinates indicate that it is inland.
Were you instructed that by council?
Yes, that's what I said. I was told that.
By council.
Correct.
And were you told to assume that the claimants knew or ought to have known that their properties were within the boundaries of a proposed park at the time they purchased them?
No, I was not told to assume that.
You don't identify clearly in your reports anywhere where you've been given assumptions by council with respect to the facts or the law. Were you given any assumptions to rely on in the course of preparation of your reports?
Well, I would disagree that I don't lay out assumptions. I typically write a "we understand" when I'm being told something. That's my way of doing it. If it is something of a fact that I deemed relevant myself from doing my analysis, I footnote it. But clearly, respondent has taken a position about the park, as has a claimant. I don't think that there's a lot of controversy, except for whether or not we take into account that claimants knew or should have known their properties they purchased were in the park.
Do you say anywhere in your report that when you refer to "we understand," that means it's an instruction from council?
I just don't use those terms, instruction from council. I've never used those terms in my entire career as an expert. I use "we understand."
Does it say anywhere in your report that when you use the words "we understand," that's something that you've been told by council?
It could also mean, when I write those words, that it's something I'm told by the party who has retained me. A witness has told me this. And so I can't confirm it through any documentary evidence. If I could, I would footnote the sentence and I would attach a document.
So as a reader of the report, one is not able to tell when you say "we understand" how it is that you've come to that understanding. Is that right?
You could ask any question, and any counsel that's ever cross-examined me could ask any question about a "we understand" to say, where did you get that information? And I'd be happy to say where I got it.
You'll agree with me that you cannot ascertain that from the document itself.
It depends upon the context of the sentence. In many instances, I think you could infer that it's from counsel. In other instances, depending upon the statement, you could infer it's from a witness.
Well, perhaps I'll take you to a few examples later on, but we'll move on. If I could ask you to look at paragraph number 12 of your report. In paragraph number 12 of the report, you make a number of statements with respect to factual matters. And in particular, you say in the last, sort of the middle of the paragraph, you're talking about the administrative appraisals. But below that, you say, particularly when factors affecting the value of the properties are taken into account, such as the limited water supply available to the area, the density restrictions, the building height restrictions, and the lack of any view of the ocean due to mangroves within the 50-meter inalienable zone from the mean high tide that cannot be cut down. So just breaking that down, you've got a number of factual issues there with respect to water supply, for example. Where did you get the information that you've included in your report with respect to the limited water supply available in the area?
Certainly. I just think it's worth noting to help answer your question. This is an executive summary, so it summarizes everything that's in detail in the report. So the water supply issue is addressed later and probably has some "we understands" about the water supply issues.
I'm asking you about paragraph 12 of your report right now, and I'm asking you in particular, were you given any instructions by council, for example, with respect to the statement that there was limited water supply available in the area?
Yes, I was told that. If we could turn to paragraph 124, that's where I address it. It's on page 44. And so here, as I would have expected, I wrote, third, we understand that there was an environmental concern with regard to the impact of these developments and could have a groundwater source for the region. And then I attached or cited the document that I was provided and told that this study would reveal that there was groundwater problems. I can't, of course, with my expertise, comment on that. That's why I said we understand that this is what this report says.
Who specifically told you that? Was it council?
Probably, I don't recall. I know on site visits we went around with some of the park rangers. I've met Mr. Piedra 4 years ago, so sometimes I forget what I did on each trip, but I know they addressed the water supply issues on our visit in 2014.
And as you candidly admitted, you don't have any expertise in the area, and so you can't comment specifically on whether or not it's accurate that there are, in fact, limited water supply affecting the value of the properties.
Correct.
Or, sorry, available in the area. Is that right?
Correct.
In paragraph number 15 of your report, you state, just trying to find this sentence. Sorry, I'm just trying to find the reference here. Well, perhaps I'll just ask you the question and see how familiar you are with your own report. You say in your report that most of the purchasers of properties in the area took place without proper due diligence. You recall making that statement in your report.
Can you direct me to a paragraph, or is that why you're wondering if I knew my report well?
I'm sorry, it's paragraph number 16.
Great.
It's the first sentence of paragraph number 16. You see that statement?
Yes.
And with respect to the comparables that Mr. Hedden has used in his report, you haven't done any independent verification or analysis with respect to the purchasers of those comparables to assess whether or not they had done proper due diligence with respect to their reports. In other words, you haven't spoken to them.
I haven't spoken to them, but the terms of them do reveal due diligence that they performed. For example, the C-71 and V-61 contracts were provided, and you can glean what information the buyers and sellers knew at the time the transaction took place from those.
Is that the extent of your knowledge with respect to those purchasers?
Yes, because all of the other sale and purchase contracts were not submitted by claimants into the record.
Sorry, but I'm speaking with respect to the purchasers of those comparables, the extent of your knowledge about those particular purchasers and their intentions with respect to the purchase of the property. You glean from those purchase contracts, is that correct?
Yes. Of course, I also was trying to assess the status of the market around the time when these properties were acquired by claimants. A market analysis is necessary for an expert to do anytime they're doing evaluation or damages calculation. And so my own analysis of the market is also supporting my view that an investor looking at those properties should have known about the risks of the properties being in the park and possibly being expropriated.
But you haven't spoken to those purchasers, correct?
I have not spoken to any of the purchasers.
And if you could turn to page 8 of your report. Sorry, page 22 of your report. In paragraph number 22 and following, you set out the history and purpose of the 1991 decree and the 1995 park law. You see that?
Are we on page 22 or paragraph?
Page 22. Page
then-
22 of your first report.
Right, I'm sorry, I thought you introduced the question saying paragraph 22. So which paragraph are you referring to?
Starting at paragraph number 68.
68, okay.
You set out the history and purpose of the 1991 decree and the 1995 park law, the 2004 opinion, and the Supreme Court and Constitutional Court decisions. You see that?
Yes,
Paragraphs, I'm referring to paragraphs 68 through 73.
correct.
And again, was this was this analysis given to you by counsel to rely upon?
It's not, well, if you call it analysis, it's certainly my own. Obviously, I discussed with counsel the nature of the issue and the documents reflecting the creation of the park. And then all of that goes to an assessment of the market for real estate in this particular area. So it's important for the valuation.
I'm focused specifically on these paragraphs which deal with what I would consider to be matters of legal issue. And I'm asking whether these specific paragraphs were written by you or whether you were given this information by counsel.
I specifically wrote, so we can set doubt aside, every word in this report with help from my colleagues. The attorneys did not write any sections of this report. This
So-
reflects my understanding of how the park was created and when, which is important again for evaluation.
And my question is, was your understanding obtained from discussions with counsel, or did you actually read and analyze the park law and come to your own conclusions?
Usually when I'm told of facts that are important, I would like to verify them. And so we would certainly look at and confirm that the initial decree was issued in 2000 or 1991. It would be important for me in my analysis to make sure that that's correct, but I wouldn't go so far as to interpret a section of it legally and satisfy myself that counsel's position on it legally is correct.
You understand that with respect to paragraph number 68, you understand that with respect to the 1991 decree, the proposed boundaries of the park did not include Playa Ventanas.
Correct. That's my understanding. It did not include Playa Ventanas.
And similarly, with respect to the Supreme Court and the Constitutional Court decisions, did you write the summary with respect to those two paragraphs based on information that you obtained from counsel, or did you read those decisions and write your own conclusions about what they concluded?
Again, these documents were given to me. They were made available to me. I confirmed simply part of what these documents say. I don't think some of these are really issues are in contention between the parties, but it was to fully set out the context under which my opinion was formed.
And if you could look at page 27 of your report. In the chart at table 5, you've got a timeline And some of this was in the presentation that you gave this afternoon. But with respect to the bullet or the timeline, February 10, 2004, you write Attorney General decree establishing BNMP boundaries 125 meters inland. Do you see that?
Yes.
And you use the word decree. You understand that the Attorney General's opinion is not a decree.
It may not. I don't frankly know the difference between laws and decrees. The precise difference, I know there is a difference, but that's not my domain.
Was it your understanding in writing your opinion that the Attorney General's opinion was a matter of law?
To me, what I was preparing this timeline for was to establish what research could have been developed in doing due diligence in order to make a proper assessment of the value of the properties.
Did you understand in preparing your opinion that the Attorney General's opinion was binding on anyone other than the ministry?
I didn't form a conclusion one way or the other. To me, the existence of such a decision, a decree, whatever it may be, would, in the minds of a buyer, create doubt and risk about buying a property in the area.
Just turning back to page 22 of your report, paragraph number 66. You state midway through the paragraph, in our view, several of the claimant's actions and statements indicate that they were aware or should have been aware before purchase that the properties were reserved for the BNMP. You see that?
I do.
And you use claimants in plural. You see that?
Yes.
And so you're referring to all of the claimants in that paragraph.
I'm not referring necessarily to all of the claimants, no. As I indicated in my presentation, it appears Mr. Gramillion was unaware
And
of the risk, of the property being in the park.
you say, in our view, who are you referring to when you say our?
That's a stylistic way in which I've always written my reports. I use the terms we or our instead of I and my to reflect the contributions of my colleagues.
So again, this was not something that you were asked to assume in the preparation of your reports. This is something that you wrote on your own, is that right?
That's definitely something I wrote on my own. I was, again, trying to do an assessment of what the market would look like for properties at the time of purchase. As I indicated, there's a number of indications that there's a high degree of risk about those properties being in the park and subject to expropriation, and I just added here that it even seems from claimants' own statements that they knew that to be the case.
If you could look at paragraph number 75 on page 24 of your report. You say in the second sentence of paragraph number 75, even though the 1995 law was inconsistent with the 1991 decree due to a typographical error, the claimant should have been aware that the BNMP's boundaries extended 125 meters inland. You see that?
Yes.
Were you told to assume that it was due to a typographical error?
I wasn't told to assume that. That is the outcome, as I understand it, from the ultimate determination by the Supreme Court that this was a typo.
Is that you're referring to the decision that was ultimately in May of 2008?
And the series of decisions leading up there too. this is what was the basis for changing and amending the law, was that the C word reference was a typo.
I'm sorry, you've referred expressly a moment ago to a decision that indicated that it was as a result of a typographical error, and I'm trying to understand which specific decision you're referring to. Is it the May 2008 decision?
Well, I think it may have started with the Attorney General's decision. But what I'm expressing to you is which document it's in or it's not is really not that relevant from my point of view, from a valuation perspective.
Well, you formed the conclusion that even though the 1995 law was inconsistent with the 1991 decree due to a typographical error, the claimant should have been aware that it was within the boundaries of the park. And I'm asking you, based on what specific decision you formed that conclusion?
Sure, and it's perhaps I should have added the word potentially in the park as opposed to in the park, because I think I've been consistently saying in my reports that there was risk. Risk means uncertainty.
And you can't now tell me which specific decision you're relying on in drawing that conclusion.
No, I don't think my understanding that it's much in contention that it was ultimately decided in that way, that there was a typographical error, whichever document it's in.
Were you instructed to take into consideration the claimant's knowledge as to whether their properties fell within the boundaries of the park in rendering your opinion?
No, I was not instructed to do so.
You're aware, of course, that there were individuals who bought properties completely within the 75-meter strip during the period from 2003 to 2008 for substantial sums of money.
Depends upon what you mean by substantial sums of money, but I would agree people bought properties within the 75-meter strip.
Well, if I can take you to perhaps one example, if you look at your reply report. Paragraph number 33. You refer to a lot in the Palm Beach Estates being sold for $800,000 US dollars. Is that right?
Listed,
Listed.
not sold. Listed for sale.
And do you know how much it sold for at that time?
It didn't.
It was listed for sale at $40 per square meter. Is that right?
Yes, one of the parcels was listed at that price.
And if you turn back to page 8 on page 3 of your reply report. Oh, sorry. Sorry, before I get to that point, were you instructed to assume that to the extent of any windfall, the Republic of Costa Rica should get the benefit of that, even if the purchase price were discounted because of the intended taking becoming known in the marketplace?
Was I instructed that Costa Rica should get a windfall as a result of that?
Yes.
No, I wasn't instructed on that. And in my view, and this is a damages concept, I don't think Costa Rica is benefiting in the way that a government would when it expropriates a business and keeps it for itself. Here, obviously, they're taking land to protect the turtles and get nothing more out of it than protection of an endangered species.
If I could ask you to look at paragraph number 69 of your reply report. you refer to this analysis in paragraph number 69 of your report, and you say about halfway through the paragraph, at paragraph 69, rather the sellers of the properties incurred the loss, and you're referring there to the sellers of the properties to the claimant. Is that correct?
Correct.
And to your knowledge, has Costa Rica compensated the sellers of the properties?
Of course not, because they sold the properties rather than seeking compensation. They sold them at a discount. The claimants got them cheaply because of the risks. And so now claimants are here seeking compensation.
Do you know if the sellers of the properties purchased those properties prior to 1991?
I don't know.
If I could ask you to look at the binder in front of you, the blue binder. You've indicated both in your report and in the presentation that you gave this morning that in your view the real estate market in the area in question is correlative to the U.S. real estate market. Is that right?
Yes.
And you rely on a number of articles in support of that proposition. Is that correct?
Correct.
And if I could ask you to turn to tab 5. And this is Exhibit R-65. This is one of the articles that you relied upon in support of that conclusion. Is that correct?
Yes, I recognize the first sentence of the second paragraph in particular.
If I could ask you to look at the 4th paragraph down. It starts, the person willing to buy in Costa Rica. You see that?
Yes.
And she says, the person willing to buy in Costa Rica, on the other hand, must understand that our market will not see a fall in prices as in the U.S., the reason being that most owners own their property outright. Few property owners used credit to purchase, and before losing money on their assets, they rather wait for the market to pick up. Again, those urged to sell are willing to make a smaller profit, but hardly at loss. This is the reason why the time for buyers is to act now, because the U.S. has experienced signs of recovery, and the numbers in Costa Rican tourism are rising again. You see that?
Yes, it's a predictive statement, a forward-looking statement the person is making.
And if I could ask you to turn to the next tab. This is Exhibit R-66. This was another article that you relied upon in support of your opinion that the markets were correlative. Is that right?
Yes, I believe so.
And on the first page, midway, it looks like the second article, it says surcharge still around Guanacaste. You see that?
Yes.
And it's dated June 2nd, 2010. You see that?
Yes.
And it says, in Guanacaste, the land prices are still high, so high that real estate businesses is not taking off as realtors waiting to happen after the hardest stage of the economic crisis last year. You see that?
I do. That
It says, for example, in Tamarindo, square meter in 2007 was 1,000, is now at 600. You see that?
Yes.
And so what this article is indicating is that she says last year, which would be 2009. You see that? Sorry, just going back to the sentence I read immediately before that. She refers
sorry,
to the
where does it say last year?
it says at the end of the first sentence, of the economic crisis last year. She refers to an economic crisis being
Thank
in
you.
2009.
Yes, I see.
And then about halfway down the second page, there's a reference to the executive director of the National Chamber of Tourism. And it says about halfway down the page, he believes that after the crisis, property prices did not fall nowhere near the proportions who experienced the real estate market in the US, where there was as low as 30% in middle-class housing. You see that?
Yes, and I can easily explain that.
I didn't ask you to explain that. If I could ask you to look
Mr.
at...
President, I think it's fair to allow Mr. Kazmarek to provide a very brief explanation.
Excuse me, I think that it's appropriate to allow counsel for the claimant to develop the premises for a question that she may want to put in just a moment.
I was going to move on to a different document.
And I think that you should then give Mr. Kazmarek an opportunity to respond to the issue you've just put down.
Yes, thank you. What happened and what makes it difficult to do valuations post the peak of the market in the area is many people continued to list their properties at the inflated levels at the peak of the bubble because they didn't want to take losses. And so there was a long period of time whereby the prices remained high and no activity took place. And that's what these people are seeing. They're still seeing high listed prices but no activity. That's what those comments mean.
Mr. Kazmarek, you understand that in preparation of an appraisal, that is why you look at contemporaneous information, not information that is obtained with the benefit of hindsight, correct?
Well, if you're doing a contemporaneous valuation, then you look at contemporaneous information. If you're doing a valuation at a historical date, you would not take that into account. But I was explaining, and this is a document just outlining and trying to help the tribunal to understand how the market evolved, including after the valuation date in this case.
So you acknowledge that you're relying on information that would not have been available in 2008 with respect to somebody who was purchasing property at that time, correct?
No, I'm not relying on that information in offering a view as to what I think would be proper compensation in this case. I'm relying on the purchase prices, which clearly don't reflect what happened post the real estate crash.
If I could ask you to look at tab 13 in the binder. This is exhibit R-161, which again is an article that you relied upon in coming to the conclusion that the markets were correlative. Is that correct?
Yes, it may have been.
And if I could ask you to look at the first paragraph of, and this is an article that appears to be dated September 12th, 2008, is that right?
Correct.
And it says, the mortgage crisis and subsequent economic downturn in the United States would portend a reciprocal slowdown in Costa Rica's coastal properties, but experienced real estate agents here are pragmatically optimistic. You see that?
Yes, I see that as again, a forecast or prognostication of what this person thinks may happen.
And there's no indication that at that point in time, it had already happened. Do you see that? You agree with that?
That it doesn't indicate what actually did happen?
That it had already happened.
No, it's not an article necessarily focused on what already had happened. It's an article, in my view, that talks about what they think may happen with the market moving forward. So it's a forecast, if you will.
And you see in the third paragraph, it says the Pacific coastal real estate market has boomed over the last 5 years. You see that?
Yes, I do, and I would agree that it was booming. If you go to the third to last paragraph by Bob Davy, who apparently Mr. Hedden talked to, he says the sky's not falling, there is just a healthy correction going on. What does that mean? That means a correction in prices falling. So that is a backward-looking statement about what has happened thus far.
Doesn't say when it started falling or by how much.
No, but I have other articles that I put in and I showed in my presentation that indicate most everyone viewed the peak to be mid-2006.
If I could ask you to look at the next page. The last full paragraph from the bottom. It says, on the whole, and it's referring to Mr. Nunez, an owner of First Realty Pacific Beach Properties in Playa Hermosa. He says, on the whole, he says, single-family homes in Costa Rica have not been affected by the U.S. mortgage crisis, although he cited 2 families from the U.S. who were forced to sell here because of mortgage finance problems back home. You see that?
Yes, I would agree with that statement that there wasn't a mortgage crisis in Costa Rica like the United States, so that factor did not materialize and drive prices down.
Now, you've said a number of times that it's your opinion that it's correlative also in terms of the timing of the downturn in the market. And if I could just ask you to look at tab 3 in this binder. This was another article that you relied upon in preparation of your report, is that correct?
I believe so, yes.
And in the third paragraph, it says the property market is by no means back to where it was in the boom years of 2006 or 2007. You see that?
Yes, I do.
So it refers to the boom years in Costa Rica as including 2007. You acknowledge that?
I acknowledge that, yes.
And again, it refers in the next line to the recession being last year. Again, by reference to the article, that would be 2009. Is that right?
Yes, that would be correct. The recession came in late 2008 in the United States and really took hold in early 2009. But the property markets were already in decline before the recession came about.
If you could turn to the next tab, tab 4. Again, if you look at, this is Exhibit R-63. This is another article that you relied upon.
Yes, the third paragraph was quoted in my presentation today.
And again, this is an article that's dated August 2008, so quite late into 2008, is that right?
Right, and as the third paragraph indicates, it says prices were down in 2008 from their peak a few years ago, meaning few usually means 2 when I see the word few, so 2006.
But you didn't actually do an analysis of sales of properties in 2007 in the Guanacaste province beyond these articles, is that correct?
I did analyze the market overall in all years from 2003 up to present day. And in my view, based upon my research and analysis, the property prices began to decline in 2007, and then declined further in 2008, and then the market just completely shut down. There are no transactions taking place whatsoever after that.
The only, as I indicated with you at the beginning of your testimony, the only documents that you've relied on in the preparation of your report are the ones that are referred to in your report. Is that correct?
Correct.
And the documents that you included in your PowerPoint are all documents that were referred to in your appendices. Is that correct?
That's correct.
And those form the basis for your conclusion.
Well, certainly, yes. I did site visits. I did talk to people. But I don't put hearsay testimony in the record to rely on it as evidence. When I get an understanding talking to people, I go out and I look for documentary evidence that supports what I'm being told.
And you haven't included in the documentary evidence any purchase prices from 2007 unrelated to the subject lots.
Right. I don't think in 2007, to my recollection, there were much of any that we could find. I certainly have done a very exhaustive...
Sorry, in all of Costa Rica?
No. In just that area that would be relevant. I'm certainly not looking for properties in areas that wouldn't be deemed comparable, like San Jose or something like that.
If you could look at tab 7. Again, this is another article that you relied upon in support of your opinion. Is that correct?
I believe so, yes.
And on the second page of the article, and sorry, this is an article that is also dated October 2010, but on the second page of the article at the top, it says we are a few years away from the height of the market in 2006 and 2007. You see that?
Yes, I do.
And you acknowledge that this article refers to the height of the market being in 2006 and 2007 with respect to Costa Rica.
Yes, it does. I mean, obviously, I look at all of the articles combined and form a view. And my view is that mid-2006 was the peak of the market, based on all the evidence I have seen.
If I could ask you to look at Exhibit 68, which is the next tab, tab 8. And this document is Central Bank of Costa Rica 2008 Annual Report, dated March 2009. And it's entirely in Spanish. You see that?
Yes.
And I take it that you could not read this report or understand it without it being translated to you. Is that correct?
Correct. I would have had one of the people on my team read and tell me what the document says.
Would they have sat down and read the document in its entirety to you in English?
The entire document to me in English, no, but they probably read the vast majority of the entire document. Otherwise, we don't typically go looking for a document. Having never read the document before, we don't know what it contains. So you have to read it to figure out what its contents are and if it's even a relevant document that might be useful for the tribunal.
I'm asking whether you've read the entirety of the contents, and I take it that you have not.
I have not, and it's not unusual in proceedings with documents in foreign languages.
Now, I take it your view is that the market was higher in 2007 than it was in 2008.
Yes, I would agree that prices were higher, but you have to also understand that there was a slowdown in market activity and a refusal by property owners looking to flip or sell their properties to reduce prices. So that's kind of a headwind in analyzing the market down in that area of the country.
But generally speaking, you would agree that market prices, fair market prices, would have been higher in 2007 than 2008, in your view?
Yes.
Let's go on just a small point. at some point over the next 10, 15 minutes. I leave it to you
This
to
is a
identify.
convenient time for a break.
Okay, well then let's take a break now and we'll reconvene at 4:15. And Mr. Kazmarek, may I remind you, you're in the witness seat. Please don't discuss your testimony with your colleagues, with counsel for the respondent or anyone else. Thank you very much.
Absolutely.